facing the police every single day.
Apparently, I think so.
Wait, get it! Get it!
Come on, Andrew, that's not necessary.
Yes, it is necessary.
No, it's not.
Dude, they're still fucking with me, man.
Well, they may be fucking with you, but you give them a bird.
Dude, it's free speech. You know why I've been doing it?
Here, I'm trying to help your buddy out today.
Is it necessary that we have so many cops?
Huh?
Is it just one?
He's dangerous, that's why, right?
Well, it's not
That you got
because
3 different
you
cop
guys,
cars?
it's because of
Because they heard I was going to come? Because they heard I was going to come? Is this a diesel?
Yeah.
Holy
It is.
shit.
Yeah.
But that's a piece of shit diesel, right?
No, this is the only one that's worth a shit. The 3.8.
Really? That's a good one?
I'm saying that because I'm helping him.
No, this is a good one. No, this is a good one. You got the best thing going. This is the
Dude, you didn't have it.
this is a Fiat diesel.
Okay, let me explain quick. Because I flipped off a person that works for the county, they literally stopped their truck, and after that I said, fuck it, I'm going to flip them all off. It's free speech, man. Okay? There you go. It's free speech, man.
He's saying you just shouldn't poke the bear.
Yeah, never. I should just get on my knees, right? Oh, there's the other piggies.
Did I tell you?
There's the other piggies. I see them.
Did I tell you that he actually called me on Wednesday of last
Yes,
week?
that is.
Thank you. And you have been sworn, yes, sir?
I have.
Thank you. All right, Mr. Coppinger.
Frank Coppinger, Code Compliance Officer for the City of Punta Gorda, and I've been sworn. Case number 2486858 was brought for hearing before the City of Punta Gorda Code Enforcement Board on May 28, 2025, at which time the board heard testimony, received evidence, and entered in its compliance order, which required the respondents to have the multiple axle trailers removed from the property and to pay case costs incurred in the amount of $26.47 within 30 days of the receipt of the order, and to cease and desist from any future violation of Punta Gorda Code, Chapter 26, Section 8.5, B Bravo 2, F Foxtrot, Chapter 26, Section 8.10, and Chapter 9, Section 9-2A Alpha. The property was brought into compliance on July 7, 2025. On August 6, 2025, I inspected the property at 415 Cooper Street and found that a multiple axle or 2 rear wheels per side trailer was being parked and or stored on the property, and that there was also more than 2 trailers being parked and or stored on the property, which is a repeat violation of Punta Gorda Code, Chapter 26, Section 8.10. On August 13, 2025, an affidavit of repeat violation and notice of mandatory hearing was mailed to the respondents via certified mail. Return receipt, which was returned undelivered on August 17, 2025. On August 20th, 2025, I posted said affidavit of repeat violation and notice of mandatory hearing on the property and at the City Hall Annex. On September 22nd, 2025, I re-inspected the property and found that the property was in compliance. The property has been in violation of the compliance order for 47 days of non-compliance from August 6, 2025 to September 22nd, 2025. I am submitting 36 photos for the record. The pictures submitted for evidence are a true and accurate representation of the condition of the site at the time the pictures were taken. I am submitting an invoice for case costs incurred in the amount of $16.86.
I got a lot here. All right. There you go.
Were there any questions?
September 22nd.
22nd.
Yes, Monday.
That they were in compliance.
Correct.
Right, so what I think I'm hearing is that the time period for which the property was not in compliance is from October 6th to September 22nd? Is that correct?
August 6th.
I'm sorry, August 6th
August 6th to September
to
22nd.
September 22nd. And in that time frame, how many inspections were made?
I have pictures. I know I took 5 straight days starting on August 5th through August 8th, I believe. I took took several days, I believe five consecutive days. I took pictures for the inspection of the multiple axle trailer being on property, because I just didn't want to do one day, driving by, so I did consecutive days.
Okay.
And the issue is the fact that it's there, or, I mean, somebody can, this is a question, not a statement. I'm assuming that somebody can just pull up to their property if they're gonna load or unload.
Correct, and that's why I went multiple days, and then if you look at the pictures, it was in the same exact location for several days.
Okay.
That's why I went multiple days, that it wasn't just a temporary that he was using, or the respondents were using it as for something at that time. I went back multiple days and took multiple pictures of the location and the time.
And how many times has this been in front of the board? You know? I don't remember.
Total, I don't know. This is the second time that I presented it to the board.
Okay. Thank you.
Sir, could you please,
Four total, I'm sorry.
state
Four,
your name for the record?
4 times total.
My name is Christopher Chase. I'm the owner of the smokehouse property.
Thank you.
Purchased in 2020.
Okay, do you have any questions for Mr. Coppinger?
Not at this time.
Okay, would you like to make a statement?
Oh, yeah.
Okay,
Certainly.
the floor is yours.
Let me give you this. This is a copy of what I've already given the state attorney, the city attorney and everything. You guys may want to read this while I'm talking to you guys. Now, I've owned this property since 2020, and I was actually able to be there 24 hours a day about 9 months later, because I was moving 2,200 miles back to Florida from New Mexico, where my wife passed away. So I've actually been harassed and by you guys, not you personally, of course, since 2020. So this is not the first violation that you guys have. Now, historically speaking, the Davis family owned this since 1948, and if you saw the vehicles that they would have had on this property up until the point of about 20 years ago, you guys would be having kidneys. Semi-trailers with multiple axles, 3-axle semi-tractors, bulldozers that are as big as my truck. So historically speaking, the property has been used for commercial use, and it's still half commercial and half residential now, according to your zoning. Now, constitutionally speaking, I've got a due process clause that this protects my right to control my property, storing trailers, unless the government follows procedures and demonstrates a legitimate public interest. Okay, I haven't had any. This is only a nuisance to government. I have not been a nuisance to anybody else in the community, so I'm not, any of my neighbors, this is not a problem to them. This is only a problem to government itself. And when the issue is a problem to government itself, and it's not involved in helping the people in any way, then we have a kind of a tyrannical situation, don't you think? Anyhow, your objections, I have no harm, no nuisance, arbitrary enforcement align with this, and restriction of last rational basis for procedural fairness. The CEB's restriction and trailer storage significantly impairs the use and or value of my property. I argue that taking regulatory action requiring just compensation, which fines, while the CEB's action may not rise to a full taking, I argue that this unduly restricts my property rights without compelling a public purpose. Under due process violations, Section 3 invokes the Fifth Amendment, but you could, I strengthen this by explicitly referring taking clause to challenge the restrictions as an overreach on my property rights. The 14th Amendment to the Constitution of the United States, no state shall deprive any person of life, liberty, and property without due process of law, nor deny to any person without its jurisdiction the equal protection of the laws therein. The relevance to this case, similar to the Fifth Amendment, this protects my property rights against arbitrary state and local government actions, the city's code enforcement, state and local actions, the city code enforcement, and their arbitrary enforcement over the last 5 years is procedural irregularities, and these directly ties to this protection. I have equal protection concerns in Section 4, which invokes this clause, arguing that selective enforcement, targeting your trailer while allowing others, violates equal protection by treating me unfairly as to others. Now, I only spent about 30 to 40 minutes driving up Cooper Street from my property. This is only 30 to 40 minutes worth of examples of violations that have not been seen by your code enforcement. You guys would like to see these? These are other people's property.
Could you mark this for the record?
Sure. There's at least 15 properties there with multiple trailers, multiple axle trailers, that have been there longer than I have been here. I've only been here 5 years. Some of those vehicles have been growing out of the ground and have been there for probably 10 plus years. So I don't think anybody has bothered those people. Further, the Declaration of Independence, very interesting. We hold these truths to be self-evident, that all men are created equal, that they are endowed by their Creator with certain inalienable rights. Among these are life, liberty, and the pursuit of happiness. Now, considering the pursuit of happiness, the founders, John Locke influence, is emphasizing life, liberty, and property. My ability to use my property for my business and or personal use could be framed as part of this pursuit, though maybe this is more philosophical than legal. The application of the Declaration is not directly actionable in court. However, it is necessary that I cite this to you guys just to give you the idea that our founders of the Constitution figured that undue actions by government are, infringes on our rights. The Ninth Amendment to the U.S. Constitution, enumeration of the Constitution, gives me certain rights. This amendment protects the right to control one's property free from excessive government interference, which I've been harassed since 2005 or 2020. This is restricting trailer storage, which is not hurting anybody at all. I don't understand your zoning in any case for having a dual axle trailer, but I guess that's neither here nor there. Anyhow, I've been absent or of harm or nuisance, and it doesn't infringe on any other citizens' rights to their property, and doesn't explicitly protect anyone else. Anyhow, the Florida Constitution also says that I have natural rights before the law, inalienable rights according to the Constitution, and it explicitly protects my rights to control and the use of property. Article 1, Section 9 mirrors the Constitution. Also, Article 1, Section 23 also mirrors the Constitution.
Mr. Chase, is there anything you want to say that's not in your written summation here?
No, that's already
Which, by
been,
the way, is excellent.
well, it's already been given to the, I'm considering litigation. I understand that you guys have quite a few cases before you were ready. I figured, what the hell, I'll just add on to the pile.
Okay, does anyone have, is there anything else you want to say before we ask questions?
Well, I mean, I just, fortunately, I have the time right now. I don't have the money to be paying for all this, but, about it.
Okay, thank you. Any questions from the board?
So when the board issued the previous cease and desist order, did you understand what it meant, was allowed or was not allowed?
According to zoning, yes, I've gone over your zoning violations, but that trailer happened to have been there because I needed a special bearing, and I was waiting about 3 days to get the bearing, and it was gone within a week. So I understand that, you know, any trailers that are there, you know, causes you guys great undue harm because it, you know, I don't know, it bothers you guys.
So the answer is you did understand?
I did understand that, but the trailer was there just so I could repair it. And it did have some trash that I was taking out of the building at the same time. You could see some garbage that was in it. So it was used for that purpose also. But I just don't, I mean, constitutionally speaking, I think your zoning laws are just not only unjust, but illegal. I think that the board should convene and think about changing the zoning. Considering so many other people in the neighborhood happen to be in violation.
Mr. Engelmann, board member, is this a business we're talking about or a private residence?
No, it's private. I'm not running a business out of there anymore. I do have a dumpster business, but I've got another piece of property where I store most of my stuff right now because of you guys here. I mean, it bothers you guys.
Great, thanks.
Okay, Mr. Chase, I don't know if this question is for you or for Mr. Coppinger, so I'll ask the question generally. Where you are located isn't it right on the border of the city of Punta Gorda and the county?
Exactly. The border line to Charlotte County is actually in the middle of Cooper Street. So literally, if you walk 1 inch to the center line, you're in Charlotte County.
Okay, but you acknowledge that your property is within the city limits of Punta Gorda?
It is. It's actually in an interesting little spot with the hospital that's there, which is obviously commercial. And it's not in the Booth Street is the dividing line of the historic district, and then Cooper Street is that little section there is just regular city of Punta Gorda.
And to your knowledge, is your property in the historic district or not?
No, it's not. Yeah.
I have a question for Mr. Coppinger. What is that property zoned as currently?
As far as,
Rachel Berry, zoning official for the record. It's a neighborhood center.
I'm sorry?
Neighborhood center.
And what does that mean?
I have a list of the permitted uses.
According to the county, it's mixed use. It's half commercial and half residential.
So the neighborhood center district, permitted uses include restaurants, conference centers, hospital and medical uses, bed and breakfast, single family and duplex dwellings, multifamily, civic uses, research and development, service organizations, indoor theaters, vocational and technical schools and centers, parks, recreation facilities, banks without drive-through, essential services 1 and 2, pharmacies, and medical marijuana treatment center dispensing facilities. And there's other uses permitted with conditions, which include residential, daycare, car wash, helistop, sidewalk cafes, parking structures, mixed-use buildings, hotel motel, group home, and mobile food dispensing vehicles on property with the permission of the property owner.
So I say that again, those last two.
The last two under uses permitted with conditions. One is a group home. There's also permanent canopy shade structures associated with a recreational facility. And the final one is a mobile food dispensing vehicle, a food truck.
So he's indicating that the trailer was there for 7 days and we're talking about 47 days?
correct. My initial inspection went for 5 days. I issued the offense, and then on that, it is upon the respondent to contact us when they come into compliance. He did not contact us till the 22nd on Monday when I went back out and re-inspected and found that the trailer was removed.
Have there been any previous fines to this location?
Fines?
Nick Wagner, code supervisor. I've been sworn. Let me check some records. I believe just case costs and all those have been paid.
And so, just so I understand, the photographs that you submitted go from August 6th through August 11th, correct? Okay, and then from August 11th until September 22nd, your position is because Mr. Chase did not contact you, he is out of compliance. Is that your position?
Correct. I have no idea when he took that trailer off.
All right, thank you.
I actually called in. I think he was on vacation, and they said he was going to be back. And it might have been the weekend. It might have been a Friday, and he was on vacation. I think during the weekend or whatever. Maybe you can recollect the time you were not there. But I did call in and talk to the lady in the in his office. So I didn't make any notes about who I talked to. Sorry.
And Mr. Chase, just for the record, the order that the board issued in May of this year, you did not appeal that, correct? I mean, judicially.
No, I haven't appealed. I've actually been very patient, and as you can see with that document there, I've spent the last couple of months doing some research and everything, and considering litigation at this point.
All right, thank you. Is there anything further?
And just for my clarity, as of right now, the property is in compliance.
For this violation.
Yeah.
There are other violations that I'm aware of that
I'm talking specifically
for this, yes. For this,
specifically about this.
specifically for this, yes, it is compliance.
Or a motion?
I do have a question.
Okay.
Follow up to my last one. According to what I'm reading here, the violation is attributed to a business, automotive performance, not to a residence. So I'm a little confused. Is business or residence?
I talked to my attorney at the time, and I had the property in my name, and he said for legal reasons, in case somebody got hurt on the property, that I should put it in a LLC. And I had my business from that I used in New Mexico, but it's a legal entity. It's a foreign entity in Florida. So I used it here to be able to what do you call it? I can't think about this. Anyhow, to put it underneath that name instead of my name personally. So there is no business there. You guys will not give me an occupational license to use that building there as a business. I can probably do something inside, but if I was to do anything outside or store anything outside, again, that would be in violation of your zoning rules, because I can't have an automotive business there according to the new rules that you guys. I think in 2005 you validated this new zoning district.
Thank you.
So this goes back then, did you say, in 2045? Are you referring to the LDRs and the land use regulations, which is not zoning, but the actual land use regulations which denoted this as neighborhood center?
Yeah, unfortunately I wasn't here when that happened, and the Davises that owned the property since 1948 apparently were sleeping at the wheel in 2005 when all this got changed. They could have easily talked to you guys and said that to just grandfather them in as either heavy industrial or commercial total for the property, and then none of this would be a moot subject right now, because they would still be able to use the property as they intended to use it and as they have been using it, with heavy equipment, earth moving equipment, like I said, the Davis family owned it. They have since moved their operations some 5 or 6 miles away towards the airport. They need a lot more room. A lot more room.
Rich, and make a motion find a respondent did have a repeat violation of compliance and order that a fine in the amount of $235 be imposed, representing a fine of $5 a day for 47 days of non-compliance from August 6th, 2025 to September 22nd, 2025, plus applicable interest of 8.9% annum, and it is further ordered that respondent is required to pay case costs incurred in the amount of $16.86. And the fine amount was selected at that low number because it appears that there was some attempt to communicate that the issue had been cleared and that communication was not able to be completed for whatever reason. And that's why it is.
Is there a second? You know, I have an issue I wanted to talk about, and that's the length of time for which the property was out of compliance. We have.
Madam Chair, I'm so sorry to interrupt. I did not hear a second to that.
No,
Was there
it's
a
a
second?
second.
Oh,
It's already
okay.
a second.
If you could just say that louder rather than just raising your hand, because that doesn't.
Okay, here's my concern, okay? We have testimony from Mr. Coppinger that the property was out of compliance for 5 days. And we have proof. Okay. Between the 11th of August and September 22nd, what proof do we have of non-compliance? I don't believe that Mr. Chase conceded that the property was out of compliance during that entire time. And the burden should be on the city to establish non-compliance. Just because, and I guess I'm getting ready to hear from Mr. Lewis, just because there's no communication does not necessarily mean non-compliance, in my view, subject to Mr. Lewis's comments.
It's more, I'm just going to roll this back, Madam Chair. We never had a motion for a prima facie case being made.
I think we need one because it's a repeat violation.
I mean, there was still if it's a repeat, it means we're still.
Do we still need a prima facie case? I thought there was a repeat violation.
Because it is a new case.
Is it a new case or is it dwelling in a repeat violation?
It's a repeat violation of a previous case.
Deputy City Clerk Jennifer Faulkner for the record. It's my understanding that for repeat violations, there doesn't need to be a prima facie finding because that was established under the compliance order that was previously entered. But if, obviously, we'll defer to the attorney's recommendation, and if he'd like the board to make that, if the board finds that that's applicable, then I'm fine to take that down in the minutes.
Okay, in the event that a prima facie case is necessary, I'll entertain a motion.
The previous motion is withdrawn
The previous motion is withdrawn, all right.
because we can't have two.
Okay, previous motion is withdrawn, thank you. So, let's discuss the prima facie case. Is there a motion? The city has established a prima facie case.
I'll make a motion that the city has established a prima facie case.
Thank you. Is there a second?
Second.
All right, there's been a motion and a second. All in favor, signify by saying aye. Aye. Any opposition? All right, the motion carries. In the event that a prima facie case needs to be established, the board has found that the city has established a prima facie case.
And one last thing, I'll bug you, then I'll leave. Just to follow the procedure, even though the respondent made a statement, we would now transfer over to his portion of the case. So I would just request that if there's any other further information he would want to put on the record, to put it on now.
Gotcha.
Yes, and
All
then
right.
proceed forward with the
All
previous
right,
motions.
for both sides, is there any further information that the city would like to address? The city would like to provide?
I have a question. When the respondent is notified that a violation exists, are they given instructions on how to communicate to the city when the respondent feels that the violation has been resolved?
Nick Faulkner, Code Compliance Supervisor, I've been sworn. Each notice that we give out has our name, has our personal phone number, as well as the office main number, as well as our email address.
So we've heard that he communicated, it was maybe on a Friday, I think he said, hi, I will let somebody know I've taken care of it. Is there a record thing of that? I mean, how does he support, or how do we refute that happened? I mean, we're talking about how many days here?
Yeah, I'm sorry, I forgot to take notes about that stuff.
No, I understand. I think what I'm looking at is the burden should be on the city.
On the statement that was sent to him, that was returned, and also what was posted, so I don't have to read the whole thing.
Well, I would expect that would be boilerplate information that goes to.
It states specifically on here that when they do come into compliance, it's their responsibility to contact us so that I do go back out and re-inspect the property.
So, what we heard under oath is that he contacted the city, and nothing was reported.
Does he have a certain date on when he contacted us?
I don't know, he was on, I think the very nice lady in the office said he was on vacation, or out of the office for sick on Thursday or Friday, so when I called, he couldn't answer the phone.
And recognize that the previous motion I made was taken into account that there's a discrepancy in time frame. And so that's why the proposed fine is, I think, relatively small, because its time frames are significantly different.
All right, Mr. Chase, is there anything else you'd like to add?
Just that, I don't understand why there should be any fines at all, considering that, I mean, in 30 minutes, I found some of the other people that are in violation of your exact code violations haven't been bothered, and they've been there for years.
Yeah, Mr. Chase, I'll just note for the record that, we have looked at those, and, I do see those. To my knowledge, they have not been cited as code violations, although I would hope that, that now that these are on the record, in the event that these properties are within the city limits, that, the city would take action to at least inspect.
Mr. Egan, just to clarify that, I don't know what pictures they are. Number one, Cooper Street, half of it is not in the city limits thing.
Yes.
And as far as other dual axle trailers, I have a list of, in my short time here, that I've opened up over 30 cases specifically for dual axle trailers in the 6 months that I've been an officer here. So it is an issue within the town that we are taking through action.
So what I'm hearing then is that this is an issue of concern that the staff on, not just Mr. Chase's property,
No,
but
like I said,
other
I have 30 other cases that myself, just me personally, that I've opened for dual axle trailers.
Okay.
On the property.
Thank you.
And I believe that requirement will change because of the, municipal overlay district, where you allow concerning what you may have in your yard.
All right, is there, I'll call for a motion if there's no more discussion. All right,
Again, Rich, motion to find the respondent didn't have a fee violation of compliance order. In order the fine, the amount of $235 be imposed, representing a fine of $5 per day for 47 days of non-compliance from August 6, 2025 to September 22nd, 2025, plus applicable interest of 8.9% per annum. It is further ordered that respondents are required to pay case costs incurred in the amount of $16.86.
is there a second?
Second,
Any discussion?
Yes. So we're okay with the 47 days. We feel that.
Right now, my personal opinion is there's no way for us to balance, okay, I did, we didn't get it, I don't know. So I specifically made the fine very small. one way or the other, that's just why that number of $5 per day.
I think we should take this as an opportunity for the city to consider multiple ways for respondents to notify the city. Telephone call, nobody answers, maybe an email, some alternative way of doing business.
And I was getting ready to say, that I am not convinced that it's 47 days. I mean, Mr. Chase's testimony is that he called to tell them it was in compliance, but that message did not get acted upon for whatever reason. So we really don't know. And I appreciate Mr. Rich's motion that it would be $5 a day for 47 days. I would propose, what do we do after this motion?
Well, we don't, if you don't want that, it's a motion, they can say no.
Got it, okay.
Just procedurally, you can either move to amend the motion, or you can let the original motion go to a vote.
Okay.
It's either way.
Whatever, okay. Well, from my perspective, I would vote no, because I think that there's insufficient proof of 47 days. And if the motion fails, I'll propose the motion. So, yes.
Okay, yes, this seems to be a procedural issue. We got into something similar to this in our last meeting over what date fines were effective. There seems to be a gap in the internal procedures as to how to figure some of these days and how to document those days, as Mr. Engelhardt was pointing out. Now, that being said, Mr. Chase had the option of, if you didn't get an answer on Friday, try again on Monday. Something in that interim puts the onus back on the property owner again. The other thought is that this is a repeat violation, so it's not like this is the first time we've seen Mr. Chase. So you know, I kind of agree with Mr. Rich that, you know, okay, minimize it, giving him the benefit of the doubt, and hopefully this will be the last time we see this property. Just my thoughts.
All right, so we have a motion and a second, correct?
Yes, ma'am.
All right, I'll call for a vote. All in favor, signify by saying aye.
Aye.
How many ayes? And opposed, nay? All right, the motion carries by a vote of 5-1. The board has found that Mr. Chase, the respondent, has a repeat violation of the compliance order and orders a fine in the amount of $235 be imposed, representing a fine of $5 per day for 47 days of non-compliance from August 6th to September 22nd, plus the applicable interest at 8.90% per annum, and further order that he be required to pay case costs incurred in the amount of $16.86. And for the record, I also wish to note that Mr. Chase submitted a written opposition, which I have looked at and considered. Most of what he was in the written opposition, if not all, he did say orally, and he also submitted photos. And Mr. Chase, I'm sure you're aware that you have the opportunity to appeal. I do appreciate your coming today, and
I can appeal this here?
there is a process, not to us.
Okay.
There is a process. I recommend that you consult your attorney.
3 days.
Okay.
Okay? And I appreciate your research.
Chair, one
Yes.
thought, this should probably be given to the clerk.
Absolutely, yeah. It is, it's part of the record, absolutely. Thank you.
Well, a certified copy was given to the city attorney, the
Okay.
city manager, and Mr. Kopinger.
Very good.
Also, I hand-delivered a copy.
Excellent. I appreciate that very much. A lot of lawyers would have done as well. Thank you, Mr. Chase.
So I guess I reserve the right to see you guys in court over the zoning issues.
Thank you. All right, the next item was hearing case number 25-8.
Yes, it is. I was hoping to get a copy. It's a tyrant site.